despair of the Supreme Court verdict that made criminals of the gay community, there is now hope. The top leadership of the country has come out in support of the previous order that decriminalized gay sex. On the show today, the message is good, but can they now walk the talk? Is Ordinance the right way to go, or are other options better, like getting a curative petition in the Supreme Court? Our pundits today will take contrary opinions on that. We have Vikash Singh joining us in studio, who says yes, Ordinance is the way to go. But disagreeing with him and saying that we should perhaps explore other options is Arvind Narain, who is a lawyer and an activist. We'll be speaking to our pundits in just a bit, and also a young audience will be asking us questions. But first, let's just see what the top leadership of the UPA has come out and said a day after that verdict.
My personal view is that these are matters of personal freedom, and I think I would agree more with the High Court. I think these type of matters should be left to individuals, and these are their choices. This country is known for its freedom of expression. So that's what I feel. Thank you.
The 377 judgment has brought about heartbreak across the country. With me, Senior Minister P Chidambaram, who was also part of the GOM which looked into this issue. So your first reaction to this judgment?
It's disappointing. It saddens me. The current Section 377 was made in the year 1860. It reflected the social and moral values of that day and age. Besides, our knowledge of psychology, physiology, genetics in 1860 was extremely poor. But today, in the year 2013, with so much knowledge about human psychology, human physiology, human genetics, to say that there is something like intercourse against the order of nature, and that is the social and moral value of today, and that therefore should be the legal value of today, is, I think, completely outdated, completely retrograde. I think the High Court judgment was a well-researched, cogently reasoned judgment. The Union government accepted the judgment, which is why we did not file an appeal against the judgment.
Yes.
In fact, we stood up in court and say, we accept the judgment, we are here to assist you on deciding the constitutionality. I think the bench should have referred it to a 5-judge bench, and they should have looked into all aspects of law. The law cannot be static. An interpretation of law cannot be static. What we have done is gone back in time to 1860. And I'm therefore terribly disappointed.
What is the option now, sir? Because they've obviously, in their 98-page judgment, they say that you also had an opportunity because you changed the law for the entire thing of the anti-rape law, and you yet retained Section 377. That's what the judgment says. Because
the High Court judgment read down Section 377 only in a limited way. It decriminalized homosexuality only among consenting adults and in private. Therefore, there was no need to amend Section 377. You read down Section 377 and 377 can remain, because between non-consenting adults, it will still remain a crime. So there was no occasion to amend the section. And the amendment of the section would have been necessary only after the final court has pronounced it. Since the matter was pending in the Supreme Court, there was no occasion to amend it. So the Supreme Court should have applied current social and moral values. For example, a court that has recognized live-in relationships,
yes,
that has recognized the legitimacy of children born out of wedlock, how can such a court say that only a minuscule fraction are LGBT? By one account, there are at least 100 million people in this country who would fall under the LGBT category. Be that as it may, even assuming it is a minuscule fraction, The Constitution protects the fundamental rights of every citizen.
Yes.
Even if it's one citizen, his right should be protected. I think the way out now is for the Attorney General to advise the government. I think there is a way out. I think the government should ask for a review or file a curative petition.
Government should.
Yes. And ask that the matter be considered by a bench of 5 judges.
What about the legislative options, sir? An ordinance or perhaps a bill?
A legislative option remains. But as I said, if you read 377 down in a limited way, there is no need for legislative changes. But that option still remains. But I think some of the reasoning of the judgment is worrying. For example, in I think a case decided by the US Supreme Court about 6 months ago.
So let's go to our first talking point on this, which is what we are asking. That's what the UPA is talking about. Is ordinance the best route? Arvind, why don't you think so?
I think first we'd like to welcome very strongly the statements by the UPA. I think it's for the first time we're hearing the political class, the leadership, the top leadership of this country speak very clearly on the fact that they're unanimous about the fact that the Section 377 should be read down. So in a sense, I agree that the political route is essential. I have no ambiguity about that entire point. If you're talking about further rights, if you're talking about further rights as far as the LGBT community is concerned. But our simple submission is really this, that we believe that we're not asking for special rights. We are saying that the lesbian, gay, bisexual and transgender population cannot be subject to the criminal law as far as the intimate lives are concerned. And our belief is this is not something which is subject to the vagaries of majority and minority opinion. Some matters are beyond the pale of majority opinion. And the point I really want to make is this. It's the role and responsibility of the Supreme Court to ensure that the rights of all citizens are guaranteed and respected. The court is to play the role of a counter-majoritarian institution. And it's very clear that regardless of what majorities think, the court has to protect the rights of the minority. And it's this responsibility which the court has failed in, and it's this responsibility which the court fails in today, it will fail with respect to other minorities tomorrow. So our point is, the Supreme Court has to self-correct itself. As Mr. Vikram said, rightly said, this is a stain on the history of the Supreme Court, and that stain must be wiped out.
And that is why you're saying ordinance, no ordinance.
That is why I'm saying our focus is that the Supreme Court has to self-correct itself. I'm not saying no ordinance. I'm saying that we welcome the opinion of the legislature.
Which is what P Chidambaram was also talking about. Vikash Singh, what is the advantage that an ordinance will have? Is it quicker?
Yeah,
that's the impression.
No, not only that. I'll tell you, because the legislature had failed the people, that is why the court stepped in the first place. That's the High Court. And when the High Court read down the law, between the High Court judgment till the Supreme Court judgment, nobody could have been hauled up for this offence. Now what has happened is, after the Supreme Court judgment, whether you go for a review or a curative petition or whichever proceedings you go back to the Supreme Court, there will be a huge time lag for the Supreme Court to decide. And in that time lag, all these people could be hauled up for offences, and this period they will remain offenders. Nobody can take that away, because the law as it stands today is that this is an offence. So the only way to actually get justice to these people would be, and the fastest way is getting the ordinance.
That's the fastest way.
That's the fastest way, because then the law will change the day the ordinance is brought in.
Very, very interesting.
That's the important point, because otherwise all this time people can be hauled up and people can suffer.
And you agree with that?
I agree with Mr. Vikash. There's no ambiguity on that point.
That's okay. So that's great. So that's one thing which the UP also obviously has to keep in mind. Our second talking point, which is also very important, is which is being brought up by many, because if the UPA is coming out and asserting itself, but did they make a mistake? Should UPA have amended the law before? Arvind Narain, when we look at the judgment, the Justice Singh is very clear. They're saying one of the reasons why we didn't get into it is because if the government wanted to repeal it, to get rid of this 377, they brought in the anti-rape law. Why did they keep 377 in? Do you think they made a huge mistake by not amending it, or if they had the intention, they should have removed it that time?
I think the issue of the rights of lesbian, gay, bisexual and transgender persons had become a political hot potato. It was being lobbed between the Supreme Court and the Parliament. Clearly, both parties had responsibilities. Both could have stepped in at the appropriate moment in time. Clearly, Mr. Chidambaram was right when he said that the Attorney General made a very excellent submission, and in court, he made the submission that 377 is an example of sexual imperialism. He went as far as to say that. And in the written submissions, he submitted that there is no legal error in the face of the Delhi High Court judgment. In our reading, that is adequate as far as Justice Singhvi was concerned. He needn't have gone into whether Parliament reformed the law or whatever. The opinion of the government was very clear. But at the same time, it was the role of the Supreme Court to protect minorities. Supreme Court cannot abdicate its responsibility either.